Well, hello and welcome to our video. We're going to talk about the 5 secrets debt buyers don't want you to know about when they sue you in Alabama. Because once you know these secrets, then that will greatly increase your chances of winning your case. And my name is John Watts. I'm an Alabama consumer protection attorney. And let's talk about what this problem is of these massive numbers of debt buyer lawsuits. Literally, there are hundreds of cases filed each week in Alabama. Usually it's a company you've never heard of, somebody called Midland Funding or Portfolio Recovery, LVNV Funding, all different. There are dozens of these companies. And most people, here's the bottom line, most people who get sued do nothing. And if you do nothing, then the debt collector, or sometimes called the debt buyer, they'll get a default judgment, which means simply you didn't show up, so you defaulted, you lose. Now, the reason most people do nothing is they just feel there's no hope. They go, well, years ago I owed Chase Bank or Bank of America or Capital One, and now I'm being sued and there's a lawyer suing me, so I guess there's no chance of me being successful. Well, learn these 5 secrets. Give yourself a chance at winning your case. Let's get right into it. Secret number 1, answer the complaint. Answer the lawsuit. Most people don't do this, and so they lose automatically. That's that default judgment we talked about. Now, you have a limited amount of time to answer. We have other videos and articles that talk about what does it mean to be served in Alabama. But once you're served in district court or small claims court, you only have 14 days to respond or to answer the lawsuit. Now, if you've been sued in circuit court, you have 30 days from being served. And again, we have other videos that talk in more detail about how do you answer, but just understand, you must answer the lawsuit. They don't want you to answer it. The debt collectors don't want you to, because if you don't answer, then you lose. And now they can start garnishing your wages, garnishing your bank accounts, even selling your home and other property. So if you don't answer, it gives them a tremendous advantage over you. So answer the lawsuit. And then normally what happens after you answer a lawsuit is you go to trial. And let me just put it this way. If you think of the whole sort of journey of you've been sued going all the way to the end, this moment in time when you are served is the biggest danger point, the most dangerous area that you will ever face. And so a lot of people think, oh, well, that would be the trial. No, it's right now, because the vast majority of people simply do nothing. They don't answer a lawsuit. So make sure that you answer a lawsuit. Stay alive. Keep fighting for another day. So that's the secret number 1, answer the lawsuit. Secret number 2, show me the title. Now, if you're old enough, you may remember the old Wendy's commercial where it's kind of the grandmother looking at this hamburger and there's really no meat there, and she goes, "Where's the beef?" Okay, that's what we want to do here. These debt buyers, these debt collectors come in and they say they own the debt. There's a big difference, though, in saying you own the debt and proving you own the debt. Now, if we take a step back, let's keep in mind there's a difference between you owing a debt and the debt buyer owning the debt. So I owe money on my house. That does not mean I owe that money to you or to Midland Funding or Portfolio Recovery. And they can't simply sue me and say, well, John Watts admits that he owes money on his house. That's not enough. They have to prove they own the debt. And so how do they prove it? Well, the key is the purchase agreement. So this is usually a 30, 40-page document that is the actual contract where the original creditor, let's say that's Chase Bank, is selling the debt to, let's say, Midland Funding. And so you think, well, it's pretty natural. They would just produce these purchase agreements. They hate producing them. They act like it's the secret formula, or what's the KFC secret recipe. These are not secret, but they act like they are. And so they do not want to produce this to the judge. Now, one reason is because these agreements usually say from the original creditor to this debt buyer, by the way, don't rely on anything that we put in about these accounts that we're selling you. If you've ever bought a car as is, then you get the idea here. The original creditor is saying, look, I don't make any promise that any of this information is accurate. Well, the debt buyers don't want to come into court and say, Judge, you can trust these documents. These are the gospel truth. Oh, and by the way, when we bought these documents, we were told that there's no promise any of these are correct. It's a little contradictory, so they don't want to do that. So what they do want to come in is show you and show the judge the, quote, bill of sale. It's a one-page document. It says Chase Bank and Midland Funding, sold some assets. Chase Bank sold the assets to Midland, and Midland now owns them. Well, what do they buy? What are the agreements? What are the terms and conditions of the sale? What are the representations made about the accounts that supposedly were sold? You have to look in the purchase agreement. And the bill of sale will even say this. So make these debt buyers prove they own the debt, not simply claim that you owe the debt. They'll want to focus on, well, didn't you have a Chase card and you admit you didn't totally pay it off, and see there, Judge, we're done. That's what the debt collectors want to do. Make them prove first that they own the debt. Because if they don't own the debt, then there's no point going forward. Well, what if they prove they own the debt? And I'll tell you this, in a decade of doing this, that would be incredibly rare. I'm trying to think of a time where out of all the hundreds and hundreds and hundreds of cases I've handled where they have proven they've owned the debt. But let's just give them the benefit of the doubt and say somehow they proved that. Secret number 3, the collector must prove the underlying debt. In other words, that you owe the debt. I don't mean just in general terms. Go back to my example where they say, well, didn't you have a Chase credit card? Yes. And you didn't pay it off, did you? No. That's where they want to stop. They need to prove the details. What are the terms of the contract? What's the interest rate? They go, oh, well, we surely Chase Bank followed that in the monthly statements. Well, how do we know? We can tell from the monthly statement what interest rate was applied. Is that what your contract said? Usually at this point, the debt buyer, the debt collector starts going, well, come on, we can't be expected to know all that information. We're lucky to get the documents that we get here. We got 4 of your monthly statements. That's all we need. No, what's the interest rate? What's the late payment charges? When's the due date? When do we know that you get hit with a late fee? How about the credit limit? What's the over the credit limit fee? What was the credit limit? All these are in the contract. They have to prove that. Not simply say, well, come on, you had a credit card and you didn't pay it, so Judge, you just need to trust us on what we're saying is owed. Well, there's a big difference. I might owe $500 or $5,000. They have to prove those details, so don't let them skip that step. Secret number 4. Usually the debt collector, and I'll say this, in a decade I've seen maybe 3 or 4 times out of, 500 or 600 cases where a live witness shows up. So usually no live witnesses show up for the debt collector. So what they try and do to get around this is 2 things. They'll question you, we'll talk about that in a second, but then they'll say, I do have a witness. So a case I had one time, they brought a court reporter and the lawyer said, Judge, we have a witness here. And the judge kind of raised his eyebrows like, well, this will be unusual. And so he said, call your first witness. And the collection lawyer reached in his briefcase and he said, we call Susie Smith by affidavit. And the judge looks at me and I'm like, yeah, that's goofy. Okay. But this is what they try and do. Here's an affidavit. An affidavit's a sworn statement that says, I promise I'm telling the truth. But here's the deal. You can't cross-examine a piece of paper to say, is this really true? And how do we know the affidavit's true? You might remember a few years ago, some news stories broke about companies like Chase and other companies that had people signing affidavits swearing they were based on personal knowledge. All the records have been carefully examined. It turned out these people were doing, let's say, 1,000 affidavits a day. Well, if they work 10 hours, that's 100 an hour. So what is that? I don't know, 40 seconds, 45 seconds per affidavit to carefully review all the account statements. They weren't doing that. Then it turned out they had people signing affidavits that had been dead for 6 months, but they're still signing them, 6 months after they died. Well, how did that work? Obviously, that did not work. So there's no reason to believe these affidavits. Now, I will say this about 3 different courts in Alabama. Small claims court, the judge is allowed to, but does not have to, accept an affidavit. Now, in district court and circuit court, as long as you object, the judge has no discretion. They cannot accept an affidavit because we have this idea of you can cross-examine a witness. You can't cross-examine a piece of paper. So even in small claims court, obviously you have your lawyer will make this argument, but if you're doing it on your own, I'll say this. If you do this on your own, which is a valid option, we have some resources for you, so definitely get with us. But here's just sort of a brief overview of it, is the idea of affidavits, again, you can't cross-examine them, and that's really set up in small claims court for when 2 neighbors are fighting, okay? And we're going to get a third neighbor, and we're not going to drag him down to court. He's going to just do an affidavit. It's not designed for these professional plaintiffs, these Midlands and LVNVs and Velocity and Portfolio Recovery, who file all these lawsuits. They need to bring their own witnesses, not just bring an affidavit that literally will have stuff rubber stamped on it or circled. And it's just insane when you look at these things. So remember this secret. Usually they won't have witnesses, and they're going to try and get you to admit that you owe the debt and that they own it. And again, we have a whole series of videos and things that will help you with this, but you cannot guess. You cannot speculate. You must tell the truth. And so when they ask you, well, now you know that we, Midland Funding, bought this debt. How would you possibly know that? You have no way of knowing that. So you just answer it truthfully and say, I have no idea if you bought the debt. So remember this secret. Now, secret number 5. After you win, normally you can sue the debt buyer. Not always, but normally you can. Because typically winning in Alabama means you do not owe the debt to the debt collector. So let's think about that. Midland Funding sues you. You win. That means you do not owe Midland Funding. So how did Midland Funding credit report that you owed them money? How did they sue you and say that you owed money when you really don't? How did they or their sister company, Midland Credit Management, send you collection letters or make collection calls saying you owed money when a judge has said you do not owe the money? So here's 3 basic options. You do nothing, and that's an option. Some people choose that. You can just hope the collector does the right thing, so they come off your credit report, they leave you alone. And again, some people choose that option. Most people, though, say, you know what, I want to take some action. Maybe I'm going to make sure it comes off my credit report. Or for a lot of folks, they sue the debt collector and say, wait a minute, you don't get to file a bogus lawsuit against me, mess up my credit report for 6 months or 2 years or however long you did, make all these collection calls to me, and then you show up to trial with nothing, and now you get off the hook scot-free? No. There will be consequences to filing a bogus lawsuit against me. That's what most people do, and that's typically our approach. But remember this, knowledge alone is worthless. So you have a lot of knowledge. You got these 5 secrets now. Look at our other videos or other articles. You can gain a tremendous amount of knowledge. But unless you combine that knowledge with action, it's worthless to learn the knowledge. Now, if I read all the books in the world on exercise, but I never get off the couch, what good did that do me? No good. So take this knowledge. Whether that's hiring a lawyer, representing yourself, just do something with it. So if you want to talk about your options, give us a call, 205-879-2447. Here's your 5 basic options. We'll go over these in a quick phone call. File bankruptcy, pretty rare. Occasionally it's a decent idea. Fight the lawsuit on your own. If you go that route, we'll help you do that. Settle the lawsuit on your own. For some people, this makes sense. Usually it's not a good idea. You can hire a lawyer to fight the lawsuit or to settle the lawsuit. And we can explain to you our approach on this. We have a very simple approach on it. So I hope you go through those options, then you decide what's best for you. So appreciate you sticking with me and watching this entire video. Look forward to talking to you soon. Again, just give us a call, 205-879-2447. Ask to speak to Carolyn. She'll set us up a phone call. And you can always reach us in case you're not at alabamaconsumer.com while you're watching this. You can always go there, alabamaconsumer.com. We have easy ways to contact us there. But probably the easiest is just pick up the phone, 205-879-2447. Appreciate you watching this and look forward to talking to you soon. Okay, bye-bye.